is this. This is a case that's been going on for a long time. The original suit was filed by Mr. Wzorek back in the 80s, actually. And it's really an incredible story when you look at what's transpired over the last couple of decades and how little resolution has been reached with respect to some tremendous damage that was done. The short story is this. Mr. Wzorek, ultimately pro se, was, as you said before, the first person to defeat the city in a Shackman decree case. His attorneys had basically abandoned him, or he had fired them for what he felt was questionable conduct in violation of his rights, and ultimately went on to try it by himself. The federal judge in that case, Judge Brian Barnett Duff, found conclusively that the city had in fact fired him for political reasons. The city had alleged originally that Mr. Wzorek had damaged a truck, and that was the basis for his termination. Upon cross-examination of the city's experts and actually upon questioning by Judge Duff, the city ultimately admitted that in fact the day that Mr. Wzorek was supposed to have damaged this truck that led to his firing, he in fact was not even at work, and that they were basically framing him for something that he had not done and using that as a pretext on which to terminate him. Mr. Wzorek won that case, won significant damages against the city, which at that time was a real cause célèbre because nobody had ever been successful in a Shackman case. At that point it becomes really interesting, and as we go back through the record in this case, it really becomes troubling, because it seems like every day that I get more documents in this case and I go back through it, I find more and more instances of questionable conduct on the part of what appears to be the city of Chicago, but in fact may involve different personnel within different levels of the federal judiciary. And what I mean by that is this. We have specific instances where transcripts in Mr. Wzorek's case have been physically altered throughout the course of the underlying trial, and then on appeal, when the record on appeal was prepared, it is our contention that the city's attorneys in that case, or somebody working for them or under their direction, actually withdrew key parts of the transcript, and as a result transmitted an altered record on appeal that removed from the examination of the appellate court the critical findings of fact and conclusions of law with respect to Judge Duff's ruling in this case. And Judge Duff's ruling was very clear and unequivocal. He had found that the city had terminated Mr. Wzorek for political reasons. He found that the city's conduct with respect to its litigation of this case and other things that they had done during the course of the termination proceedings had caused significant emotional distress damages to Mr. Wzorek, and that the city was responsible for those on a financial basis. And all of that material was excised from the record, so that when the appellate court went to look at the record and try to find the basis for Judge Duff's determinations, that information was no longer there. And so that to me, in a nutshell, is what we're here for right now. Justice was never done in Mr. Wzorek's case because he was never compensated to the level that Judge Duff had originally crafted in his equitable ruling, which in clear and uncertain terms said that if Mr. Wzorek cannot work for the rest of his life, then the city is obligated to pay him for the rest of his life because of their conduct leading to his pain and suffering.
That was a direct quote?
Yes.
And that direct quote never made it to the appellate transcript?
Right, never made
on
it
appeal.
Now, the interesting thing about Mr. Wzorek's case, and as I said, it starts to read like a spy novel in some ways, or something out of Scott Turow, because there are things that took place in this case that honestly I, as a former prosecutor, as a former legal and policy advisor at the Illinois Commerce Commission, I've seen aggressive litigation tactics, and I don't have any problem with that. I believe that an attorney's obligation is to aggressively pursue strategies, defenses, etc., that best represent their client's interests, so long as those have a solid foundation in fact and law. Where I have a problem is when you've got people that are particularly officers of the court who are essentially shifting or playing with the record and shifting the tables so that ultimately individuals like Mr. Wzorek lack the ability to get a fair hearing, lack the ability to get real access to the justice system. And we talked about the manipulation of the transcripts. One of the other things that's particularly troubling is that, and as relates to the tape issue that you said before, in the federal courts, there's essentially a structure in place. It's a two-level structure that allows for the public to believe in the integrity of the record. And that two-tiered system is supported by audio tapes of the proceedings that take place, and then a printed record, the transcripts, that can then be matched one against the other to determine whether in fact the paper is a fair reflection of what actually transpired. And the clerk's office in the federal courthouse has forms that allow you to order copies of both. If you want the transcripts, if you want the tapes, you can have those. For reasons that I cannot discern, Mr. Wzorek's case, the tapes were denied him when he made specific requests related to his concerns that the transcripts were being altered during the course of the trial, for example. The court denied him that. The court clerk's office denied him that as well. And then strangely, in the oral argument before the Seventh Circuit Court of Appeals,
by the city.
By the city.
Yep.
The attorney for the city that argued that case on appeal actually withdrew the only record of the oral argument before the Seventh Circuit Court of Appeals and never returned it. The
only record, so there wasn't even a transcript record of that?
Not that we were ever able to find.
Okay.
Now, if one has been produced, we have never seen it, and it would have been produced off of the tape that was removed by the city. So my question is, how is it that someone from, well, anyone, but how is it that someone from the city corporation counsel's office can get access to original records and take those out of the courthouse and then not bring them back and thus deprive anybody, the public, the ability to be able to go in and examine this and verify whether in fact the record it's being presented.
Okay, having said that, the only verifiable documentable record, which is the audio tapes in this case, of the appeal made by the city at the appellate level, that for Gene's case, his emotional pain and suffering damages were denied, even though he won originally, and we found that the transcripts as filed were different. That judgment has been left to stand, correct? The city is claiming that their victory on appeal, denying Gene his damages for emotional pain and suffering, are in effect, it's mind-boggling. When I first ran across this, and I called Northwestern's Center for Wrongful Conviction and talked to the executive director, and we had him on the conference call, he was blown away that this type of activity could happen. And he knew the judge in question personally. And I kind of got into this from Northwestern's oversight with students looking into the wrongful death issues here in Illinois that mounted up, and then Governor Ryan basically had to pull the plug on that because there wasn't any resolution to that, despite the fact that the state legislature had been sitting on this mountain of evidence of fraud and corruption for the better part of 2.5, 3 years. But, okay, Gene, you're in the middle here. You're the bridge between Mr. Jones and Mr. Locke. Before we get into this, make a couple of personal comments. You've been in this how many years?
This has been about 21 years.
21 years.
Right. And basically I'm proud to be sitting here with you guys because I didn't figure, I'd ever get this far. But the point is that they're forging these things. I was in court. I seen this happen. I was there. The thing that hurt me the most is when I got an old attorney Gordon had to help me, and he went up to Judge Duff and asked for the tapes. And we got it on transcript where Duff says, I can't give you the tapes. If I give you the tapes, they'll be playing it on TV every night, and everybody will want their tapes. So I was blown away by it.
That's in the transcript?
Oh, yeah, we got
Duff's
the transcript.
comments saying
right.
that I can't give you the tapes because if I give you the tapes, it's going to be on the evening news, blah,
yeah,
blah, blah.
They'll be playing it every night, and they'll be playing other people who want their tapes then. It's right there in the transcripts, and Bob's has seen this. Bob can
Yeah,
verify.
I think I remember that.
And then the one where we got the actual record, that just about a month, I think the 26th of June, Rosenthal took out the